adulterated serial number, end quote, in clear violation of his probation. Later, he argued he didn't know he was a felon. 6 circuit courts, including the 10th, have determined that the government does not need to prove a defendant knew he was a felon to convict for this crime. Despite this, Judge Gorsuch wrote 2 separate opinions that argued in favor of making it harder to convict felons who possess guns. In one, he wrote that sometimes following precedent, quote, requires us to make mistakes, end quote. I find this concerning. Following precedent in this case was not a mistake. It led to the conviction of a felon who should not have had a firearm. Judge Gorsuch has also stated that he believes judges should look to the original public meaning of the Constitution when they decide what a provision of the Constitution means. This is personal, but I find this originalist judicial philosophy to be really troubling. In essence, it means that judges and courts should evaluate our constitutional rights and privileges as they were understood in 1789. However, to do so would not only ignore the intent of the framers, that the Constitution would be a framework on which to build, but it severely limits the genius of what our Constitution upholds. I firmly believe the American Constitution is a living document intended to evolve as our country evolves. In 1789, the population of the United States was under 4 million. Today, we're 325 million and growing. At the time of our founding, African Americans were enslaved. It was not so long after women had been burned at the stake for witchcraft. And the idea of an automobile, let alone the internet, was unfathomable. In fact, if we were to dogmatically adhere to originalist interpretations, then we would still have segregated schools and bans on interracial marriage. Women wouldn't be entitled to equal protection under the law, and government discrimination against LGBT Americans would be permitted. So I am concerned when I hear that Judge Gorsuch is an originalist and a strict constructionist. Suffice it to say, and I conclude, the issues we are examining today are consequential. There is no appointment that is more pivotal to the court than this one. This has a real-world impact on all of us. Who sits on the Supreme Court should not simply evaluate legalistic theories and Latin phrases in isolation. They must understand the court's decision have real-world consequences for men, women, and children across our nation. Thank you, Mr. Chairman.
Senator Hatch for 10 minutes.
Well, thank you, Mr. Chairman. Judge Gorsuch, welcome back to the Judiciary Committee. This will be more of an ordeal than your last fitness for the appointment. It will be just as apparent. I've served on this committee for 40 years, and some things in the confirmation process never change. The conflict over judicial appointments is general, in general, and over this nomination in particular, is a conflict over the proper role of judges in our system of government. I've long believed that the Senate owes the President some deference with respect to his qualified nominees. Qualifications for judicial service include legal experience, which summarizes the past, and judicial philosophy, which describes the present and anticipates the future. Judge Gorsuch's legal experience is well known. My Democrat colleagues have referred to the American Bar Association's rating as the gold standard for evaluating judicial nominees. The ABA's unanimous, well-qualified rating for Judge Gorsuch confirms that he has the highest level of professional qualifications, including integrity, competence, and temperament. Judicial philosophy is both the more important qualification and the more challenging to assess. It refers to a nominee's understanding of the power and proper role of judges in our system of government. Over the last several weeks, I've addressed this issue on the Senate floor and in opinion pages around the country by contrasting what I have called impartial judges and political judges. An impartial judge focuses on the process of interpreting and applying the law according to objective rules. In this way, the law, rather than the judge, determines the outcome. A political judge, in contrast, focuses on a desired result and fashions a means of achieving it. In this way, the judge, rather than the law, often determines the outcome. In my experience, a Supreme Court confirmation process reveals the kind of judge that senators want to see appointed. A senator, for example, who wants to know which side a nominee will be on in future cases, or who demands that judges be advocate for certain political interests, clearly has a politicized judiciary in mind. The New York Times reported last week that the most prominent lines of attack against this nomination will be that Judge Gorsuch is, quote, no friend of the little guy, unquote. Something is seriously wrong when the confirmation process for a Supreme Court justice resembles an election campaign for political office. This dangerous approach contradicts the oath of judicial office prescribed by federal law. When taking the seat on the U.S. Court of Appeals in 2006, Judge Gorsuch swore to administer justice without respect to persons and to impartially discharge his judicial duties. His opponents today demand, in effect, that he violate that oath. Advocates of such a politicized judiciary seem to think that the confirmation process requires only a political agenda and a calculator. When a nominee is a sitting judge, they tally the winners and losers in his past cases and do the math. If they like the result, it's thumbs up on confirmation. If they don't, well, it's thumbs down. What if, for example, Judge Gorsuch's record on the appeals court was as follows? He voted against the plaintiff in 83% of immigration cases, against the defendant in 92% of criminal cases, denied race claims more than 80% of the time, and agreed with other Republican-appointed judges 95% of the time. I can just hear the cries of protest, accusations that he favors certain parties and is hostile to others, and threats of filibuster. That is, in fact, the record of a U.S. Circuit Court judge nominated to the Supreme Court, but not the one before us today. It is the record of Judge Sonia Sotomayor, as described by Senator Charles Schumer at her July 2009 confirmation hearing. Not only did he champion her nomination, but he offered that statistical summary of her record as proof that, as he put it, quote, she is in the mainstream, unquote. Oh, what a difference an election makes. Alexander Hamilton wrote about the importance of judicial independence, what Chief Justice William Rehnquist later called the crown jewel of our judicial system. What Chief Justice William Rehnquist later called the crown jewel of our judicial system. That the only way for him to prove his independence is by promising to decide future cases according to certain litmus tests. In other words, judicial independence requires that he be beholden to them and their political agenda. If simply describing that unprincipled position is not enough to refute it, the confirmation process is in more trouble than I thought. Judge, I know that the integrity of the judiciary, fairness to the litigants who come before you, and your own oath of office are your highest priorities. You will be in good company by resisting efforts to make you compromise your impartiality. When President Lyndon Johnson nominated Judge Thurgood Marshall to the Supreme Court, Senator Ted Kennedy, my friend, who would later chair this committee, said, quote, we have to respect that any nominee to the Supreme Court would have to defer any comments on any matters which are before the court or very likely to appear before the court, unquote. Now, that was 50 years ago. When Justice Ruth Bader Ginsburg appeared before this committee in 1993, she said, quote, "A judge sworn to decide impartially can offer no forecasts, no hints for that would show not only disregard for the specifics of the particular case, it would display disdain for the entire judicial process," unquote. Now, in a speech earlier this year, Justice Sotomayor said this, quote, "What you want is for us to tell you how, as a judicial nominee, we're going to rule on the important issues you find vexing. Any self-respecting judge who comes in with an agenda on the important issues you find vexing. Any self-respecting judge who comes in with an what you don't want as a judge." Now, I'll close by reading from a letter we received from dozens of Judge Gorsuch's Harvard Law School peers. After describing how they were of all political, ideological, religious, geographical, and social stripes, the signers wrote, quote, "What unites us is that we attended law school with Judge Neil Gorsuch, a man we've known for more than a quarter century, and we unanimously believe that Neil possesses the exemplary character, outstanding intellect, steady temperament, humility, and open-mindedness to be an excellent addition to the United States Supreme Court," unquote. I agree with that appraisal by people from all walks of life, from different political views, people who agree with you and don't agree with you, but acknowledge that you're a great judge. And I look forward to this hearing, Mr. Chairman. Thank you.
Yeah, thank you, Senator. Senator from Vermont.
Oh, thank you, Mr. Chairman. I did find interesting the senator from Utah spoke about the Justice Sotomayor saying that these are the reasons in her nomination, the speech, these are the reasons why Republicans should vote for and Democrats vote against her. I would note, that, of course, that Senator Hatch voted against her. Today marks the first time the Senate Judiciary Committee has met publicly to take action on the Supreme Court vacancy that resulted from Justice Scalia's death 13 months ago. Because just hours after we learned of Justice Scalia's sudden passing, the Republican Majority Leader declared that the Senate would not provide any process to any nominee selected by President Obama, despite the president having nearly a year left in his term. This was an extraordinary blockade. It was totally unprecedented in our country's whole history. Some liken it to the action of the tyrannical kings who claim that they have sole control, as one of our senators referred to here a few minutes ago. But it was a blockade backed by then-candidate Donald Trump. Committee Republicans met behind closed doors and declared that they would surrender the independence of this committee to do that obstruction is one of the greatest stains on the 200-year history of this committee. Remember, the Judiciary Committee once stood against a court-packing scheme of a Democratic president that would have eroded. Once stood against a court-packing scheme of a Democratic president. Republicans on this committee are guilty of their own court unpacking scheme. And the blockade of Chief Judge Merrick Garland was never grounded in principle or precedent. While Senate Republicans were meeting in back rooms to block President Obama's nominee, extreme special interest groups were also meeting in private to vet potential Supreme Court nominees for then-candidate Donald Trump. I do not know of any other Supreme Court nominee who was selected by interest groups rather than by a president in consultation with the Senate as required by the Constitution. Now, Senate Republicans made a big show last year about respecting the voice of the American people in this process. Now, they're arguing that the Senate should rubber stamp a nominee selected by extreme interest groups and nominated by a president who lost a popular vote by nearly 3 million votes. And that president has demonstrated hostility to our constitutional rights and values. He's leveled personal attacks against federal judges and career prosecutors who dare to see his promised Muslim ban for what it is, unconstitutional. He called our constitutionally protected free press, quote, the enemy of the American people. When the president's chief of staff says the nominee before us has the vision of Donald Trump, well, that raises questions for people who have actually read the Constitution or cares about the rights it protects. More than perhaps any confirmation hearing for the last 30 years, I expect this nominee's judicial philosophy will play a central role. Now, Judge Gorsuch has spent more than a decade on the federal bench. He graduated from Harvard Law School. He clerked for the Supreme Court. He served in the Department of Justice. He received a unanimous, well-qualified rating from the American Bar Association. All things very positive for a Supreme Court nominee. And if all those things I've read were sufficient reason to confirm a nominee to the Supreme Court, well, of course, Chief Judge Merrick Garland, who had exactly the same qualifications, but was refused by the Republicans, would be sitting on the court today. That's why philosophy becomes important. In contrast to past nominees like John Roberts, whose judicial philosophy was not clearly articulated when he appeared before this committee, Judge Gorsuch appears to have a comprehensive originalist philosophy. It's the approach taken by jurists such as Justice Scalia, or Justice Thomas, former Judge Bork. While it has gained some popularity within conservative circles, originalism, I believe, remains outside the mainstream of modern constitutional jurisprudence. It's been 25 years since an originalist has been nominated to the Supreme Court. Given what we've seen from Justice Scalia and Justice Thomas and Judge Gorsuch's own record, I worry that it goes beyond being a philosophy and it becomes an agenda. We know that conservative groups that vetted Judge Gorsuch and the millionaires who fund them have a clear agenda. One that's anti-choice, anti-environment, pro-corporate. And these groups are obviously confident that Judge Gorsuch shares their agenda. The first person to interview Judge Gorsuch in this process explained these groups did not ask who's a really smart lawyer who's been really accomplished. Instead, they saw a nominee who understands these things like we do. After all, Judge Gorsuch has been described by a former leader of the Republican Party as a true loyalist and a good, strong conservative. Now, the concerns I have about Judge Gorsuch's judicial philosophy and the process by which he is selected, the views of the president nominated, I hope and expect, Judge, that you will answer my questions and the questions of all the senators, both parties, as clearly as possible. You know, it's not enough to say in private that the president's attacks on the judiciary are disheartening. I need to know that you understand the role of the courts in protecting the rights of all Americans. I need to know that you could be an independent check and balance on the administration that's nominated at you and on any administration that might follow it. Judge Gorsuch, these hearings occurring the week after Sunshine Week are the first opportunity for the American people to hear your views on the role of the courts, the meaning of our Constitution. Like the founders who did not know what legal questions would be presented in the decades to come, they set this constitutional process. It's important to determine whether you understand how the court has a profound impact on small businesses and workers, on law enforcement and victims, on families and children across America. It is not contrary to the duties and obligations of a Supreme Court justice to consider the effects of their rulings. The court's aspiration, after all, is to provide equal justice under law. That's inscribed in Vermont marble over the doorway to the court. Judge Gorsuch, these hearings will help us conclude if you're committed to the fundamental rights of all Americans. Will you allow the government to intrude on Americans' personal privacy and freedom? Will you elevate the rights of corporations over those of real people? And will you rubber stamp a president whose administration has asserted that executive power is not subject to judicial review? It's important to know whether you serve with independence or as a surrogate to the president who nominated you, or the special interest groups that provided that president with your name. Now, I approach these hearings with these thoughts in mind. I can honestly say I've yet to decide how I'm going to vote in this nomination. Unlike those who blocked the nomination of Chief Judge Merrick Garland, I believe it's my constitutional responsibility to fairly evaluate a president's nominee to the Supreme Court. I have voted for Supreme Court nominees. I've voted against others. I recall going on the floor of the Senate right after our Democratic leader said he would vote against John Roberts for Chief Justice. I was the next speech. I said I would vote for him. But I'm going to base my determination on the full record at the conclusion of these hearings, just as I've done for the 16 previous Supreme Court nominees since I've been in the Senate. The Supreme Court is a guarantor of the liberties of all Americans. Judge Gorsuch, when you took the oath to sit on the federal bench, you spoke these following words that are in a judicial oath. I will administer justice without respect of persons and do equal right to the poor and to the rich. If confirmed, you have to be a justice for all Americans, not for the special interests of a few. You know, I can't think of any time in our nation's history when that commitment is more important than it is now. That's what I've been thinking of all weekend long. The stakes for the American people could not be higher. We know that in Vermont, but America knows that. I thank you, Mr. Chairman.
Yeah, and thank you, Senator Leahy. Now to Senator Cornett.
That was great.
Thank you, Mr. Chairman. Judge Gorsuch, welcome to you and your family. As you can already tell, this is going to be a much different experience than you had 10 years ago when you were confirmed by voice vote of the entire United States Senate to the 10th Circuit Court of Appeals to a life tenured position. The Senate Judiciary Committee undertakes no task more important than the one before us, considering a nominee to the United States Supreme Court. As you know, historically, these used to be pretty routine, but that's until judges became seen as policymakers rather than as impartial interpreters and appliers of the law. The nation is watching, and I think that's a really good thing. At a time when fewer and fewer American citizens know our founding story and the principles upon which it is based, I think this is a wonderful opportunity for a teachable moment. And I would encourage you to take every opportunity to engage in that. We're considering a nominee, of course, left by the death of Justice Antonin Scalia. And as we've heard before, Justice Scalia was unique. His wit and style brought the Constitution to life for lawyers in their first year of law school and for the American public at large. He led the most important legal revolution in our lifetimes, tethering judicial interpretation to the written text. What a concept. This is part of the broader project which the nominee before us, Judge Neil Gorsuch, described as, quote, reminding us of the differences between judges and legislators, that judges should strive to apply the law as it is, not to decide cases based on their own moral convictions or the policy consequences they feel might serve society best. In one dissent, Justice Scalia wrote along similar lines that, quote, convictions or the policy consequences they feel might serve society best. And that a free and intelligent people's attitude toward us can be expected to be quite different. The people know that their value judgments are quite as good as those taught in any law school, and perhaps better. The framers, I believe, shared Justice Scalia's and your modest view of the role of judging. Alexander Hamilton wrote, for example, the judiciary may truly be said to have neither force nor will, but merely judgment. After Justice Scalia's death, Senate Republicans decided to let the American people in this last presidential election choose his successor.
In Judge Gorsuch, President Trump chose one of the most accomplished lawyers and jurists of his generation. As we've heard, he's a husband and a father of 2 daughters, lives in his native Colorado, and if confirmed, would be our only Western justice. Justice Gorsuch attended Columbia and Harvard Law School and, of course, got his doctorate at Oxford. After clerking for 2 Supreme Court justices, Byron White and Anthony Kennedy, he went to work for a startup law firm that grew to be one of the nation's most prestigious, where he spent a decade, as he put it, working in the trenches of the law. As a recovering lawyer and judge myself, I think it's critically important. Judge, it means that you understand better than most the impact of your decisions, actually having represented real-life clients. The law is not just an academic or intellectual exercise. It has real consequences for real people, and I'd encourage you to talk about those real people that you came in contact with during your legal and judicial career. After serving his country at the Justice Department, Judge Gorsuch, as I mentioned earlier, was nominated and confirmed to the 10th Circuit. Not one of our Democratic colleagues then country at the Justice Department, Judge Gorsuch, as I mentioned earlier, was nominated and confirmed to the 10th Circuit. Reason to do so. In the decades since, Judge Gorsuch has written hundreds of opinions on the Constitution and innumerable laws. He's demonstrated that he actually reads the text carefully to get the right result. I'm reminded that there is a difference between what we sometimes loosely call a strict constructionist and a textualist, and I'd invite you to make that point during some of your testimony. As you can see here today, his jurisprudence reflects brilliance and humility, the humility of a man committed to the Constitution and the law. That body of work is the best guide for the kind of judge Judge Gorsuch will be. Answers to questions posed during these hearings, we've already heard about specific issues, cannot and should not be a guide. You're not a politician running for election, Judge, as you know. In the dissent I mentioned earlier, Justice Scalia warned that, quote, confirmation hearings for new justices should deteriorate into question and answer sessions in which senators go through a list of their constituents' most favored and most disfavored alleged constitutional rights. It should not be the forum in which you seek the nominee's commitment to support or oppose them. So we're not here to ask you, even though some might, how you will vote in specific cases. And it'd be wrong for you to prejudge those cases, as you know. And that's the same reason why, for example, Ruth Bader Ginsburg, during her nomination here, and that's the same reason why, for example, Ruth Bader Ginsburg, during her no disregard for the specifics of a particular case, it would display disdain for the entire judicial process. Can you imagine what a litigant might think if the judge before whom he or she was to present their case said before they heard a word how they were going to decide the case? That's why it's improper for you, as you know, to prejudge cases in your testimony before the committee. And our colleagues know that as well, but I expect them to ask a few questions nonetheless. Well, lately we've heard from some that they should criticize you for failing to rule for a sympathetic constituency in one case or another. But of course, as you know, Judge, if you follow the law and the facts wherever it may lead, sometimes it's for the police, sometimes for a criminal defendant, sometimes it's for a corporation, sometimes it's for an employee, sometimes it's for the government, sometimes it's against the government. That's how the rule of law works, and that's good for all Americans. One law professor at Harvard wrote, following the law, regardless of the parties, is in the long run, it protects the little guy a lot better than a system rigged to favor one side. Because of your qualifications and a demonstrated record of following the law, other than a few special interest groups, I believe you've got a broad spectrum, really surprisingly broad spectrum of people supporting your nomination. One of your colleagues on the left wrote in Washington Post, the Senate should conform Judge Gorsuch because there's no principled reason to vote no. Another liberal constitutional scholar joined a letter that stated Judge Gorsuch has the unusual combination of character, dedication, and intellect that will that stated, Judge Gorsuch has the unusual combination of character, dedication, and intellect, from whom this committee will hear, wrote in the New York Times that liberals should back Judge Gorsuch because he would live up to the promises to administer justice with respect to persons and to do equal right to the poor and to the rich. So, Mr. Chairman, the list goes on and on. So I'm very pleased the American people are about to learn why President Trump chose you as his nominee for the Supreme Court. I look forward to hearing from Judge Gorsuch, and I would encourage my colleagues to carefully consider the nominee on the merits. To hearing from Judge Gorsuch, and I would encourage my colleagues to carefully consider the nominee on the merits.
Gorsuch, welcome to you and your family. I've often read stories about earlier Supreme Court nominees and how little politics played any role in the selection and vetting of the nominees. Those of us on the Democratic side, as you can hear, are frequently warned not to let politics to be part of this decision. When I consider the path to this historic hearing, this plea rings hollow. The journey began with the untimely death of Justice Scalia in February of 2016. President Obama met his constitutionally required obligation by nominating Judge Merrick Garland to fill that vacancy in March of 2016. Senate Republican leader Mitch McConnell announced that for the first time in the history of the United States Senate, he would refuse Judge Garland a hearing and a vote. He went further and said he would refuse to even meet with the judge. It was clear that Senator McConnell was making a political decision, hoping a Republican president would be elected. He was willing to ignore the tradition and precedent of the Senate so that you could sit at this witness table today. In May and September of 2016, Republican presidential candidate Donald Trump released a list of 21 names, including yours, that he would consider to fill the Scalia vacancy. President Trump thanked the Federalist Society and the Heritage Foundation, two well-known Republican advocacy groups, for providing the list that included your name. Your nomination is part of a Republican strategy to capture our judicial branch of government. That is why the Senate Republicans kept this Supreme Court seat vacant for more than a year, and why they left 30 judicial nominees who had received bipartisan approval of this committee to die on the Senate calendar as President Obama left office. Despite all of this, you're entitled to be judged on the merits. The Democrats of the Senate Judiciary Committee will extend to you a courtesy which Senate Republicans denied to Judge Garland: a respectful hearing and a vote. Judge Gorsuch, you've been nominated to a lifetime appointment on the highest court in the land, and this court has the final say on matters of fundamental importance affecting all Americans. You have a lengthy record before the 10th Circuit and will ask many questions. We have found in the past that nominees try their best to dodge most of the questions, but it's our job to try to still seek the truth. At the nomination hearing of Justice Ruth Bader Ginsburg, my friend and predecessor, Senator Paul Simon, set forth a standard for Supreme Court nominees. I've noted this with each Supreme Court nominee that I've questioned. He said, quote, "You face a much harsher judge than this committee, and that's the judgment of history. And that judgment is likely to revolve around the question, did you restrict freedom or did you expand it?" Let me be clear, when I talk about expanding freedom, I'm not talking about freedom for corporations. We the people does not include corporations. Senator Simon could never have imagined that the Supreme Court would give corporations rights and freedoms that were previously reserved only for individuals under the Constitution. And yet that's where we find ourselves with the Roberts Court. It's often said the Roberts Court is a corporate court because of its pro-business tilt. A study by the Constitutional Accountability Center found that the court ruled for the U.S. Chamber of Commerce 69% of the time. The court has certainly favored big business on issues like forced arbitration, corporate price fixing, workplace discrimination cases, just to name a few. But the Roberts Court has gone further than just ruling the way corporate America wants. In the 2010 Citizens United case, the Supreme Court held for the first time that corporations have the same rights as living, breathing people to spend money on elections. And that was followed. Corporations have the same rights as living, breathing people to spend money on elections against employees based on the corporation's assertion of religious belief. I don't recall ever seeing a corporation in the pews of Old St. Patrick's Church in Chicago. Our founders never believed that corporations were endowed with certain inalienable rights, but we're seeing the Supreme Court expand the rights of this legal fiction, a corporation, at the expense of the voices and choices of the American people. This strikes at the heart of the Supreme Court's promise to provide equal justice under the law. Judge Gorsuch, you took part in that Hobby Lobby case when it was before the 10th Circuit. As I read the case, I was struck by the extraordinary, even painful lengths the court went to protect the religious beliefs of the corporation and its wealthy owners, and how little attention was paid to the employees, to their constitutionally protected religious beliefs, their choices as individuals, and the burdens that the court's decision placed on them. I want to hear from you about a pattern I've seen in your decisions on the 10th Circuit. Court's decision placed on them. I want to hear from you about a pattern I've seen in your decisions on the 10th Circuit. To recognize their rights or defend their freedoms. Cases like Trans Am Trucking, which we've already spoken to. Alphonse Madden. I had a chance to sit down with him just last week. He was the truck driver from Detroit who was driving around Chicago in the middle of January when a malfunction in his trailer froze the brakes and he was forced to pull over on the side of the road. Al sat there on his cell phone with the dispatcher for the truck company who told him, don't leave this truck no matter what, and if you do, pull the trailer with you. Well, that was a big problem because the brakes were frozen and it would have been a safety hazard. And so he waited and waited, and the hours passed, and he started feeling numb and sick. You see, there was no heater in the truck, and according to his recollection, it was so cold, it was 14 degrees below. Not as cold as your dissent, Judge Gorsuch, which argued that his firing was lawful. You cited a strict textualistic argument to make your point, but you chose the text that you focused on. Thank goodness the majority in this case pointed out that common sense in the Oxford Dictionary supported the majority view. Compass Environmental Incorporated, another one of your cases, your dissent would have vacated a penalty against an employer who failed to train construction employee Christopher Carter to avoid the electrocution hazard that killed him. Strickland versus UPS, your dissent would have kept Carol Strickland's sex discrimination case from going to a jury, even though your fellow judges said she provided ample evidence that she was regularly outperforming her male colleagues and treated less favorably. I want to hear more about your views on fundamental individual rights that the Supreme Court is tasked to defend: the right to privacy, the right for all faiths to practice their religion, the right to vote, equal protection, and the rights of women. The committee has received 2 letters from students who you taught last year that raise some serious concerns. Tomorrow we'll get to the bottom of it, I hope. We've learned you were an aggressive defender of executive power during the time of the Bush administration. In June 2004, after the Abu Ghraib torture scandal, I authored the first bill to ban the cruel, inhuman, and degrading treatment of detainees. That legislation became the McCain Torture Amendment, which passed the Senate in December of 2005 by an overwhelming 90-9 vote. But when President Bush signed the amendment into law, he issued a signing statement claiming he had the authority to ignore the McCain Amendment. Turns out you were deeply involved in this unprecedented signing statement. We need to know what you'll do when you're called upon to stand up to this president or any president if he claims the power to ignore laws that protect fundamental human rights. You're going to have your hands full with this president. He's going to keep you busy. It's incumbent on any nominee to demonstrate that he or she will serve as an independent check or balance on the presidency. There are some warning flags. February 23rd, White House Chief of Staff Reince Priebus said, and I quote, "Neil Gorsuch represents the type of judge that has the vision of Donald Trump," close quote. I want to hear from you why Mr. Priebus would say that. Make no mistake, when it comes to the treatment of workers, women, victims of discrimination, people of minority religious faith, and our Constitution, most Americans question whether we need a Supreme Court justice with the vision of Donald Trump. With my constitutional responsibility firmly in mind, I look forward to questioning tomorrow. Thank you, Mr. Chairman.
Thank you, Senator Durbin. Now, Senator from Utah.
Thank you, Mr. Chairman, and thank you, Judge Gorsuch. Welcome to the committee. I also want to welcome your friends, family members, supporters, former colleagues, and people you've worked with over the years who have come to show their support. I know they're proud of you, and they're proud of you not just because of what you've done, what you've accomplished professionally, but also because of who you are personally, a man of integrity, a man of great accomplishment, a man of character, and a man of faith. Everyone knows that a Supreme Court confirmation hearing can be dramatic, even emotional at times. The stakes are high. As senators, we understand that there are a few things that are more important than the obligation that we're performing here, than the duty that we're carrying out in connection with this process. These days, it seems like standing for a confirmation hearing in the United States Senate after being nominated to the Supreme Court of the United States can appear a little bit like running for political office. As we've seen over the last few weeks, there are interest groups out there, some supporting you, some opposing you, out there waging campaigns almost as if they were running a campaign for someone pursuing public office. Maybe that's why, especially on this side of the dais, it can be easy to forget that a nominee is an ordinary citizen. Perhaps not ordinary in the usual sense, but at least that person is not a politician. You, sir, are not a politician, which means that the acrimony, the duplicity, the ruthlessness of today's politics are still a little foreign to you, are still quite unfamiliar to you. I hope that they will remain unfamiliar to you. In a former life, when I was a practicing attorney, I had the good fortune of appearing in front of you on the 10th Circuit. And so I know from my own personal experience that you're one of the best judges in the country. You come to oral argument prepared, and you ask fair, probing questions that are designed to get at one thing and one thing only, which is what the law says and what the law requires in each individual case, depending on the facts and circumstances of that case. You weren't there to promote a personal agenda or a political agenda, and you're not there to grandstand. You're there to listen to both sides of the argument in the case. You write thoughtful and rigorous opinions. They're careful and they're well-reasoned, and they're even interesting and pleasant to read, which is very difficult to achieve in the world of appellate litigation. Now, I know I'm easily entertained, but I find your opinions particularly interesting. You have the resume of a Supreme Court justice, but I think what's most impressive, and for our purposes, what's most important about your career and about the approach you take to the law is your fierce independence from partisan influence and from any personal biases that you might otherwise be inclined to harbor. The judiciary is set apart from, and in a way set far above, the other branches in our republic, the other organs of our constitutional system, specifically because we allow it to invalidate and interpret the actions of the elected branches. So we've got two branches of government that are political in that they're run by people who are elected and stand for re-election at regular intervals, thus making themselves directly accountable to the American people. Our confidence in our entire system, including our confidence in the American judiciary, depends entirely on judges just like you, judges who are independent and whose only agenda is getting the law right, regardless of whether any particular judge or any particular litigant or any particular member of the public might like or dislike the outcome in that case. You are essential to making us accountable because unless you do your job right, we aren't held accountable because our laws don't stand. That's what makes your role and your particular unique approach and your particular unique commitment to this so important. Now, I want to take a moment to address some of the unique criticism and commitment to this so important. Now, I want to take a moment to address some of my colleagues might claim that you're outside the mainstream. In fact, we've sadly heard some of that already today. We've heard arguments to the effect that you were an originalist, and we've heard assertions to the effect that originalism is somehow so far out of the mainstream that it's dangerous. Well, I remind my colleagues who have raised such concerns or who might be harboring them that if this is the case, then they're going to have to acknowledge the fact that there's a pretty broad spectrum of people on the United States Supreme Court who they might be painting with that brush. Justice Elena Kagan, before she was Justice Kagan, when she was standing before this committee in the second day of her confirmation hearings, said, and I quote, referring to the Founding Fathers and the need to figure out what the Founding Fathers understood about particular words, about how those particular words were used by the founding generation, said sometimes they laid down very specific rules, sometimes they laid down broad principles. Either way, we apply what they tried to do. In that way, we are all originalists. That was on June 29th, 2010, before this committee. Moreover, these out of the mainstream arguments. Moreover, these out of the mainstream addressing you, referring to you as an originalist just doesn't stick. This is not a description that was attributed to you the last time you stood before this committee and went through a confirmation process. Nowhere in the record is there any reference to you being outside the mainstream. In fact, your nomination to the United States Court of Appeals for the 10th Circuit was so remarkably uncontroversial that one senator, and only one senator, Senator Lindsey Graham from South Carolina, was the only member of this committee who even bothered to show up at your confirmation hearing. Now, I would have been there too, Judge. I was not yet a member of the United States Senate. You were confirmed unanimously by voice vote without a single no vote. I'm sure that some of my colleagues will question your independence because in their view, perhaps you haven't sufficiently criticized the comments made by some of today's politicians. Personally, I think you've made your views on this subject very clear. I'm sure some of my colleagues will complain that you aren't providing any hints as to how you might rule in any particular case. But that, however, is a reason for your confirmation, certainly not against it. In our system, judges don't provide advisory opinions. They don't make legislation. They don't legislate. They don't make law. They don't set policy in the same sense that those things are made in the political branches. They decide cases and controversies only after each side has had the opportunity to make its case before the bench, and they do so outside the realm of political influence. In an odd twist, some of the same colleagues who will question your independence will also push you to answer questions that you simply can't. I'm sure that some of my colleagues will pick apart some of your rulings. They'll try to say that you're hostile to particular types of claims or to particular plaintiffs. I don't think it's productive to evaluate someone's judicial record by looking at who wins or who loses in his courtroom, at least outside the context of evaluating how the law was interpreted in that case. It goes without saying that in our system, you face the same burden of convincing a court, regardless of who you are. And judges don't decide cases. They certainly should never decide cases based on their own personal preferences. But to my colleagues who go down that road, the record shows with abundant clarity that you apply the law neutrally in all cases, without regard to the parties. Finally, I'd urge my colleagues to keep in mind that while Judge Gorsuch's reputation won't be affected by how we treat his confirmation, the same can't always be said of the Senate. The night Judge Gorsuch was nominated, he said the U.S. Senate is the greatest deliberative body in the world. I tend to agree, but these days it seems like this title is more of a challenge than an observation. I tend to agree, but these days it seems like this title is more of a challenge than an observation. So I hope we prove you right this week. Thank you very much, and I really look forward to hearing answers to the questions we'll raise to you.
Thank you, Senator Lee. Now, Senator Whitehouse.
Judge Gorsuch, welcome. As we discussed when we met, the question that faces me is, what happens when the Republicans get 5 appointees on the Supreme Court? I can't help but notice the long array of 5-4 decisions with all the Republican appointees lining up to change the law to the benefit of distinct interests, Republicans at the polls and big business pretty much everywhere. Let's look at the 5-4 decisions. First, helping Republicans at the polls. All the Republican appointees' 5-4 decisions on election law favor Republicans at the polls. 6-0. Helping Republicans gerrymander, paving the way for the Republican red map plan that won the House against the American majority in 2012. Jubileer, 5-4, all the Republican appointees. Helping Republican legislatures keep Democrat-leaning minorities away from the polls with targeted voter suppression laws. Shelby County, 5-4, all the Republicans. Bartlett v. Strickland, 5-4, all the Republicans. Helping corporate money flood elections and boost Republican candidates. McCutcheon, 5-4, all the Republicans, counting the concurrence. Bullock, 5-4, all the Republicans. And the infamous Citizens United decision, 5-4, all the Republicans. In each area, the court made new law, 5-4, and each decision predictably helped Republicans win elections. At 6-0, it's a partisan rout. Then look at cases that pit corporations against human beings. All the 5-4 Republican appointee decisions line up to help corporations against humans. Citizens United and the political money decisions should again count here. All 3 of them 5-4, all the Republicans. Then come decisions that protect corporations who've harmed their employees. In pay discrimination, Ledbetter, 5-4, all the Republicans. In age discrimination, Gross, 5-4, all the Republicans. In harassment cases, Vance, 5-4, all the Republicans. In anti-retaliation cases, Nassar, yep, you guessed it, 5-4, all Republicans. Then there are the decisions that protect corporations from class action lawsuits. Walmart v. Dukes, 5-4, and Comcast, 5-4, both all Republicans. Then there are decisions that help corporations steer customers away from juries and into corporate-friendly mandatory arbitration. Concepcion and Italian Colors Restaurant, both 5-4, both all Republicans. The Iqbal decision, 5-4, all Republicans, help bar the courthouse door for all types of plaintiffs. All of this helps keep corporations away from juries, the one element of government hardest for corporations to control. Indeed, as you know, tampering with a jury is a crime. The court also helps big business against unions. Harris v. Quinn, 5-4, all Republicans. Last year, Friedrichs was teed up as a 5-4 body blow against unions when Justice Scalia died. With a new 5-4 court, they'll be back. Throw in Hobby Lobby. Corporations have religious rights that supersede health care for their employees. 5-4, all Republicans. Add Heller and McDonald, reanimating for gun manufacturers a legal theory a former Chief Justice once called a fraud. 5-4, all Republicans. Help insulate investment bankers from fraud claims? Why not? Janus Capital Group, 5-4, all Republicans. Chamber of Commerce v. EPA gave corporate polluters an unprecedented victory. Again, 5-4, all Republicans. That's an easy 16-0 record for corporations against humans. To me, every time seems like a lot. There's no coincidence here. Big business has law groups out trolling for test cases to go get those cases before the friendly court. The Republican politico-industrial complex piles in with amicus briefs and floods to tell the Republican appointees on the court what it wants. Republican justices are even starting to give hints so big business lawyers can rush to get certain cases up pronto to the court. It's kind of a machine. Special interests set up and fund front groups. The front groups appear as amici before the court. The amicus briefs of the front groups tell the court what the special interests want. The court follows the amicus briefs. The decision benefits the special interests, and the special interests pour more money to the front groups. On it goes like turning a crank. The biggest corporate lobby of them all is winning better than 2-1 at the court. This 5-4 rampage is not driven by principle. Over and over, judicial principles, even so-called conservative ones, are overrun on the court's road to the happy result. Stare decisis. That's a big laugh. These were law-changing decisions, many upending a century or more of law and precedent. Textualism. The Second Amendment uses the military term, arms, and talks about militias, but never mind that when the gun lobby wants something. Originalism. There's a particularly good one. Find me a founding father who planned a big role for business corporations in American elections, or one who would have countenanced the steady strangulation of the civil jury without so much as a mention of the Seventh Amendment. The Citizens United majority even fiddled with court procedure to get to the decision it wanted to deliver, dodging its way around a record that would have belied their findings of fact, setting aside that their findings of fact were factually preposterous, as events have shown, and that appellate courts are not even supposed to make findings of fact. It's not just us who notice. Top writers and scholars describe the Roberts Court as essentially a delivery service. Jeffrey Toobin wrote in 2009, even more than Scalia, Chief Justice Roberts has served the interests and reflected the values of the contemporary Republican Party. Linda Greenhouse in 2014, I'm finding it impossible to avoid the conclusion that the Republican-appointed majority is committed to harnessing the Supreme Court to an ideological agenda. Norm Ornstein has described what he called the new reality of today's Supreme Court. It is polarized along partisan lines in a way that parallels other political institutions and the rest of society in a fashion we have never seen. Studies of the court's decisions show it's the most corporate-friendly court in modern history, with Justices Roberts and Alito vying to be the most corporate-friendly justice. And with Justices Roberts and Alito vying to be the most corporate-friendly justice. The majority of Americans think a person won't get a fair shake in this court against the circuit you held for a corporation having religious rights over its employees' health care. Your record on corporate versus human litigants comes in by one count at 21-2 for corporations. Tellingly, big special interests and their front groups are spending millions of dollars in a dark money campaign to push your confirmation. We have a predicament. In ordinary circumstances, you should enjoy the benefit of the doubt based on your qualifications. But several things have gone wrong that shift the benefit of the doubt. One, Justice Roberts sat in that very seat, told us he'd just call balls and strikes, and then led his 5-person Republican majority on that activist 5-4 political shopping spree. Once burned, twice shy. Confirmation etiquette has been unhinged from the truth. 2, Republican senators denied any semblance of due legislative process to our last nominee, one, I would say, even more qualified than you, and that's saying something. Why go through the unprecedented political trouble to deny so qualified a judge even a hearing if you don't expect something more amenable to come down the pike? Those political expectations also color the benefit of the doubt. Finally, the special interests who've done so well in that 5-4 extravaganza of decisions are now spending millions and millions of dollars campaigning. Interests who've done so well in that 5-4 extravaganza of decisions are now spending millions and millions. These special interests also supported the Republican majority, keeping this seat open. I'm afraid that all costs whoever now sits in that seat the benefit of the doubt to answer this question: Will you saddle up with the other Republican appointees and launch the court 5-4 again on another massive special interest and Republican election spree? I hope, whatever we may disagree about on this committee, we can at least agree that we can't have a court where litigants in these 5-4 decisions can predict how they'll do based on who they are. Because here's what it looks like now. If they're big Republican election interests, they'll win every time. If they're corporations against a human being, they will win every time. And, Your Honor, every time seems like a lot. Thank you, Chairman.
D. Graham.
Thank you, Mr. Chairman. There's a reason I did not do this litany with Democratic nominees that appeared before the committee. I don't think it would have made any difference in terms of how other people voted, and I didn't expect them to vote with the Republican majority, Elena Kagan and Sonia Sotomayor. I could have spent a lot of time talking about how antagonistic they are to the Second Amendment, in my view, how the unborn doesn't have much of a chance in their court, how the environmentalists always win, and there's no government too big to be said no to. The reason I didn't do that is because I thought they were qualified. And if you believe this has been a great plan to get a Trump nominee onto court, then you had to believe Trump was going to win to begin with. I didn't believe that. Obviously, I didn't believe that, saying all the things I said, followed closely by Ben. But apparently, what I said didn't matter, and that's okay with me. The American people chose Donald Trump, and here's what I can say about the man in front of us. No matter who had won our primary, no one could have chosen better than Neil Gorsuch to represent conservatism on the Supreme Court. So Donald Trump deserves to be congratulated for listening to a lot of people and coming up with, I think, the best choice available to a Republican president in terms of nominating somebody who is going to keep the conservative philosophy alive and well in the court. And I doubt if you'll be disappointed many times with Judge Gorsuch, but he's a pretty independent guy from what I can tell. You'll probably be more disappointed. I've never been disappointed with Sotomayor and Kagan in the sense I knew what I was getting. They always vote with the liberal bloc. They're very qualified people. Sometimes the court comes together 9-0 to reject something, but most of the time, people break along the lines of where they came from. And I think Sotomayor and Kagan came from a view of the law that I don't accept in terms of who I would have chosen. Kagan came from a view of the law that I don't accept in terms of who I judicial philosophy from the left. I thought they led exemplary lives, quite frankly. There were a lot of attacks on them that I didn't echo because I thought, give me a break. Really, are these the two worst women in the world? They lived exemplary lives, were highly qualified, and that's why I voted for them. I thought that's what we should be doing, and I'm beginning to wonder now how the game is played. I do remember when I voted for them, how many good editorials I got from papers that nobody in South Carolina read. I miss Harry. Harry's around here somewhere, Harry Reid. He said something nice about me. I can't find it. But he basically said that I wished more people would follow Senator Graham's lead when it comes to voting for very highly qualified nominees. He said that on the floor. Maybe that'll happen in the future. Well, time will tell. Now, as to whether or not this man is highly qualified, I'm dying to hear the argument that he's not. You may not like the view he has of the law, but I'm dying to hear somebody over there tell me why he's not qualified to be sitting here when a Republican president occupies down the street. Now, when you look at the Federalist Papers, I saw the musical Hamilton. It was pretty good. Reading his work was even better. And in the Federalist Papers 78, 87, I can't remember the number, basically what he tells us is that the role of the Senate is to make sure that the president doesn't pick someone specially favored for their state, an association to their family, someone really cronyism, I guess, is what we're supposed to be doing. And most Supreme Court justices, up until modern times, basically were confirmed with a voice vote. So things have changed, and we can't lay all the blame on our Democratic friends about politicizing the selection process. And we can't lay all the blame on our Democratic friends about politicizing the selection process. And I'm sure Justice Sotomayor and Kagan had wished on a couple of days they had not chosen that path, but I think they made it through, quite frankly, with flying colors. So the issue for me is I'm waiting to hear somebody over there tell me why you're not qualified for the job that you're seeking. 2,700 decisions and you've been overruled once. An academic record, the reason I didn't do all the things you did at once. An academic record, the reason I didn't do all the things you've handled yourself. I think you should be proud of the way you've handled yourself on the court. I think all the statements by your colleagues who know you better than anybody up here, when no TV cameras rolling, say nothing but great things about you, even people who have a different philosophy. So I just want you to know that from my point of view, you're every bit as qualified as Justice Sotomayor and Kagan. I think you're just as good a man as they are to fine women. And over the course of the next couple of days, the American people are going to get to understand who you are and within limits your judicial philosophy. They're going to want you to decide every case they don't like here, and you'll have to say no. And there's a reason I didn't ask Justice Sotomayor and Kagan to give me an opinion as to what they would do when they got on the court, because I knew they wouldn't tell me that. Didn't really feel comfortable asking them that. As to Justice Garland, the one thing I can say for sure is that when Justice Scalia passed on February the 13th, we'd already had 3 primaries on the Republican side, and the campaign was in full swing on the Democratic side. I thought long and hard about that. Are we doing something unfair here by not allowing the current president to nominate somebody and fill a vacancy in the last year of their presidency after the political process had started? So when I started looking around at what other people thought, here's what Joe Biden thought in '92. If someone steps down, I'd highly recommend the president not name someone and not send up a name up. If Bush did send someone up, I would ask the Senate seriously consider not having a hearing on that nominee. It would be a pragmatic conclusion that once the political season is underway, and it is, action on Supreme Court nominations must be put off until after the election campaign is over. That's what my friend Joe said in 1992. The bottom line here is I have no doubt in my mind if the shoe were on the other foot, the other side would have delayed the confirmation process until the next president were elected. In 100 years, when we've had the president of one party in power and the Senate in the hands of another party, I think we have one person confirmed in the last year of a term. So I don't feel like any injustice has been done anybody here. And the bottom line, when you read Democratic words from the past, they're saying basically what we said. The one thing I can say is that I've been consistent. I've voted for everybody since I've been here. 4, Alito, Justice Roberts, Sotomayor, and Kagan, and I feel all 4 had one thing in common. No Republican would have chosen Sotomayor or Kagan, but how could a Republican say they were not qualified for the job they had? They had lived an exemplary life, well qualified, and had years on the bench. Now the shoe is on the other foot. I remember after I voted for Ms. Kagan, all the headlines in the Washington Post were, "This will ensure that Graham gets primaried." They were right. That's not the only reason to my primary opponents, but that was the main reason. And I made it through just fine. And I don't know how we got here as a nation. Scalia had 98-0. Ginsburg, I think, was 96-3. What happened between now and then? How did we go from being able to understand that Scalia was a well-qualified conservative and Ginsburg was a well-qualified liberal and recognized that elections mattered? I don't know how we got there, but here's what I hope, that we turn around and go back to where we were, because what we're doing is going to destroy the judiciary over time.
Thank you, Senator Graham. Now, Senator Klobuchar.
Thank you, Mr. Chairman. Welcome, Judge. We've already met once before in my office, and all of us on the Judiciary Committee are looking forward to hearing from you, and welcome to your family as well. This committee has no greater responsibility than the one before us today. Our Constitution, our laws, and our values all depend on a Supreme Court that is impartial, fair, and just. Your nomination comes before us during an unprecedented time in our country's history. We are witnessing a singular moment of constitutional and democratic unease. In recent months, foundational elements of our democracy, including the rule of law, have been questioned, challenged, and even undermined. So I cannot evaluate your credentials in the comfort of a legal cocoon. Instead, I must look at your views and record in the real world of America today. You see, you come before us this afternoon, not only as a nominee sitting at a table alone with your friends and family behind you, but in the context of the era in which we live. From the highest levels of government, we have heard relentless criticisms of journalists. 17 intelligence agencies have confirmed that Russia, an autocratic foreign government, attempted to influence our most recent election. At the same time, voting rights in the U.S. have been stripped from far too many, while dark money in extraordinary sums, adding up to an estimated $800 million in just 6 years, continues to have an outsized influence in our politics, distorting our representative democracy. Just last month, we saw the President of the United States refer to a man appointed to the federal bench by President George W. Bush as a so-called judge. And we have sadly seen hate unleashed towards religious minorities, from Jews to Muslims, venom directed at innocent Americans, from kids in restaurants being told to go back to where they came from, to a man gunned down while washing his car in his driveway. The pillars of our democracy and our Constitution are at risk. You are not the cause of these challenges, Judge, these challenges to our democracy. But if confirmed, you would play a critical role in dealing with them. This is a serious moment in our nation's history, and as representatives of the American people, it is our duty up here to determine if you will uphold the motto on the Supreme Court building itself, to help all Americans achieve equal justice under law. Before I was elected to the Senate, I spent 8 years leading Minnesota's largest prosecutor's office. I've seen firsthand how the law has a real impact that extends far beyond the walls of a courtroom, whether it's crime victims and their families or people who have seen a loved one sent to jail. The decisions made from the bench affect people living right now in the 21st century with 21st century problems. So though the U.S. Constitution and its Bill of Rights were written in the 18th century, though the 14th Amendment's guarantee of equal protection of the laws was written in the 19th century, the decisions made today affect not the lives of our 18th and 19th century ancestors, but of all Americans today. So, Judge, these hearings will not just be about your legal experience. They are about trying to understand what you would actually do on the court. For the law is more than a set of dusty books in the basement stacks of a law library. It's the bedrock of our society. We need to know how you approach the law. After Judge Merrick Garland was nominated to the Supreme Court last year, We often heard about how he is a careful jurist who decides cases on the narrowest possible grounds, who builds consensus across the ideological spectrum, who doesn't inject political considerations into his rulings. We look forward to hearing what your judicial philosophy would be on the court. Looking at your past decisions, I have questions about how you would approach your work. In a speech last year, you spoke about the differences between judges and legislators. You said that while legislators may appeal to their own moral convictions and to claims about social utility to reshape the law as they think it should be in the future, that judges should be none of those things in a democratic society. Judges, you said, should instead strive to apply the law as it is, focusing backward, not forward, and looking to text, structure, and history to decide what a reasonable reader at the time of the events in question would have understood the law to be. I want to understand better those views of the Constitution and how they square with modern-day life. Due process, equal protection of the laws, these are general and sweeping terms, and the Supreme Court, which has the power of judicial review, has the constitutional duty to be the final arbiter of what the Constitution means, rulings that can impact voting rights, civil rights, and the right of people to marry. Many of the issues we face today are ones that this country's founders never considered, and in fact never could have considered because of all the social change and innovation that has taken place. We are no longer dealing with plows, bonnets, and in fact never could have considered because of all the social change and innovation that has taken cyber crimes. And those were just the topics of the hearings I attended last week. I want to understand how your judicial philosophy, which as you suggest looks backward, not forward, may affect the rights of our fellow citizens. I also want to understand the implications of your views on legal precedent. One example of this occurs in the context of the Chevron doctrine. In stating that courts should generally defer to reasonable interpretations of executive agencies, this 33-year-old case guarantees that the most complex regulatory decisions, ones judges themselves may have little or no expertise to handle, are made by the scientists and professionals best equipped to rise to these challenges. These modern agency decisions include things like rules protecting public safety, requirements against lead-based paint, and clean water protections for our Great Lakes. Last year, in your concurring opinion in Gutierrez v. Lynch, you suggested that Chevron should be overturned. Yet this act would have titanic real-world implications on all aspects of our everyday lives. Countless rules could be in jeopardy, protections that matter to the American people would be compromised, and there would be widespread uncertainty. Judge, if you believe it is really time to overturn Chevron, then we need to know with what you would replace it. Another opinion that I want to talk about is Riddle v. Hickenlooper. In your concurring opinion, you suggest that the court should apply strict scrutiny to laws restricting campaign contributions. If the Supreme Court adopted that view, it could well compromise the few remaining campaign finance protections that are still on the books. The notion that Congress has little or no role in setting reasonable campaign finance rules is in direct contradiction with the expressed views of the American people. In recent polls, over 3/4 of Americans have said that we need sweeping new laws to reduce the influence of money in politics. While polls, as we know, aren't a judge's problem, democracy should be. When unlimited, undisclosed money floods our campaigns, it drowns out the people's voices. It undermines our elections. Other questions about your views in money in politics are raised by your opinion in Hobby Lobby. In that opinion, you found that corporations were legal persons and could exercise their own religious beliefs. This ruling leaves open the troubling argument that corporations have a right to free speech equal to that of citizens, which would invalidate the prohibition of corporations donating. These aren't the only First Amendment issues I'll raise. I want to talk about New York Times v. Sullivan and freedom of the press, as well as an area you have great expertise in, antitrust. Judge, as I consider your nomination, I'm reminded of something a justice who hailed from Minnesota, Justice Blackmun, once said. Surely, he wrote, there is a way to teach law strict and demanding though it might be, with some glimpse of its humaneness and basic good. There is room for flexibility and different answers, and not all is black and white. You see, there's a reason we have judges to apply the laws to the facts. It's because answers aren't always as clear as we would like, and sometimes there is more than one reasonable interpretation. As a prosecutor, I knew that every charging decision that we made, every case we chose to pursue, had real implications. It's the same with judges. For that we made, every case we chose to pursue had real implications. It's the same with judges. It was an hourly Minnesota grocery store worker who got his hard-earned pension. And when the court stripped away the rules that opened the door to unlimited super PAC spending, it wasn't the campaign financiers or the ad men who were hurt. It was a grandma in Lanesboro, Minnesota, who actually believed that giving $10 to her senator would make a difference. And as the granddaughter of an iron ore miner, I can tell you it wasn't a CEO or a corporate board chair whose life was saved by mining safety rules. It was the Minnesota iron ore workers, like my grandpa, who went to work every day with a black lunch bucket 1,500 feet underground in a cage. My dad, who ended up as the first kid in his family to graduate from high school and from there to community college and then to the University of Minnesota, still remembers as a little boy standing in front of the caskets of those mine workers lining St. Anthony's Church. It was the worker protections, coupled with the ability to organize as a union, that finally made those miners' jobs safe. Judge, you have been rightfully praised for your impressive academic credentials and experience. But at these hearings, I want to know more than just about your record. I want to know about how, if you are confirmed, your decisions will in fact reflect precedent and the law, whether your judgments and decisions will be good, whether they will be done in a way that will help all Americans, from that grandma in Lanesboro to that Minnesota grocery store worker. That's not politics. That's why we're having these hearings today. Thank you.
Thank you, Senator Klobuchar. Now, Senator Cruz.
Thank you, Mr. Chairman. Judge Gorsuch, welcome. Thank you for your decades of service, honorable service. Thank you for your family being here today. And thank you for your willingness to endure the spectacle of this confirmation hearing. February 13th of last year was a devastating day for those of us who revere the Constitution and the rule of law. On that day, we lost Supreme Court Justice Antonin Scalia. Justice Scalia was one of the greatest justices to ever sit on the court. He was a trailblazing advocate for the original meaning of the Constitution and a shining example of judicial humility. His death left an enormous hole and a shining example of judicial humility. His death left an enormous shoes to fill, a daunting task that I know weighs on you as you consider the enormity of what is in front of you. Today, there is a sharp disagreement about the very nature of the Supreme Court. Some people view the court as a hyper-powerful political branch. When they grow frustrated with the legislative process and the will of the people, they turn to the courts to try to see their preferred policies enacted. For conservatives, we understand the opposite is true. We read the Constitution and see that it imbues the federal judiciary with a much more modest role than the left embraces. Judges are not supposed to make law, they are supposed to faithfully apply it. Justice Scalia was a champion of this modest view of the judicial role. But had his vacant seat been filled by Barack Obama or Hillary Clinton, Justice Scalia's legacy would have been in grave danger. If they had filled his seat, we would have seen a Supreme Court where the will of the people would have been repeatedly cast aside by a new activist Supreme Court majority. We would have seen a Supreme Court majority that viewed itself as philosopher kings who had the power to decide for the rest of us what policy should govern our nation and control every facet of our lives. We would have seen our democratic process controlled by 5 unelected lawyers here in Washington, D.C. That would have been a profound and troubling shift in the direction of the Supreme Court and in our nation's future. That is why, after Justice Scalia's untimely death, the Senate chose to exercise our explicit constitutional authority, and we advised President Obama that we would not consent to a Supreme Court nominee until the people, in the midst of a presidential election, were able to choose. For 80 years, the Senate had not filled a Supreme Court vacancy that had occurred in a presidential election year, and the Senate majority rightly decided that last year would not become the first in 8 decades. The people, therefore, had a choice between an originalist view of the Constitution represented by Justice Scalia or a progressive and activist view of the Constitution represented by Barack Obama and Hillary Clinton. During the campaign, President Trump repeatedly promised to nominate justices in the mold of Justice Scalia. And indeed, he laid out a specific list of 21 judges, constitutionalists from whom he said he would choose his nominee. Judge Gorsuch was one of those 21. Issuing such a list was a move without precedent in our country's presidential history. And it created the most transparent process for selecting a Supreme Court justice that our nation has ever seen. The voters had a direct choice. The voters understood the 21 men and women from whom the president would pick. And they had a very different vision of a Supreme Court justice that was put forth by Hillary Clinton. And in November, the people spoke. In what was essentially a referendum on the kind of justice that should replace Justice Scalia, the people chose originalism, textualism, and rule of law. The people chose judicial humility. The people chose protecting the Bill of Rights, our free speech, our religious liberty, our Second Amendment, rather than handing policymaking authority over to judges on the Supreme Court. Given that history, given the engagement of the electorate nationally on this central issue, I would suggest that Judge Gorsuch is no ordinary nominee. Because of this unique and transparent process, unprecedented in the nation's history, his nomination carries with it a super legitimacy that is also unprecedented in our nation's history. The American people played a very direct role in helping choose this nominee. Like the renowned justice he is set to replace, Judge Gorsuch is brilliant and has an impeccable academic record. His judicial record demonstrates a faithful commitment to the Constitution and the rule of law. He has refused to legislate his own policy preferences from the bench, while recognizing the pivotal role the judiciary plays in defending the fundamental liberties protected in the Bill of Rights. On the night he was nominated, Judge Gorsuch channeled Justice Scalia when he explained that, quote, "A judge who likes every outcome he reaches is very likely a bad judge, stretching for results he prefers rather than those the law demands." That is exactly right. And those words should give comfort to the American people and to my Democratic colleagues. And it's worth recalling that our friends on the Democratic side of the aisle understand this, and indeed, not too long ago, agreed with it. A decade ago, Judge Gorsuch was confirmed by this committee for the Federal Court of Appeals by a voice vote. He was likewise confirmed by the entire United States Senate by a voice vote without a single Democrat speaking a word of opposition. Not a word of opposition from Minority Leader Chuck Schumer, not from Harry Reid or Ted Kennedy or John Kerry, not from Senators Feinstein, Leahy, or Durbin, who still sit on this committee, not even from Senators Barack Obama, Hillary Clinton, or Joe Biden. Not a one of them spoke a word against Judge Gorsuch's nomination a decade ago. And the question this hearing poses to our Democratic colleagues is, what has changed? What has changed? 10 years ago, Judge Gorsuch was so unobjectionable, he didn't merit even a whisper of disapproval. In the decades since, he has had an objectively exemplary record. By any measure, he has shown himself to be even more worthy of the bipartisan support he received back then. Unfortunately, modern reality suggests that's probably not something my Democratic colleagues feel they can do in today's political environment. Many probably believe they have no choice but to try to manufacture attacks against Judge Gorsuch, whether they want to or not, just to preserve their own political future and protect themselves from primaries back home. We're seeing some of these baseless attacks already. Most recently, some Democrats have tried to slander Judge Gorsuch as being, quote, against the little guy because he has dared to rule based on the law that Congress has passed, and not on the specific identity of the specific litigants appearing before him. This is absurd. For one thing, many of these same critics have spent the last 8 years attacking the Little Sisters of the Poor, a Catholic charity of nuns, for having the audacity to live according to their deeply held religious beliefs. You really need to take a long look in the mirror if one day you find yourself attacking nuns, attacking the Little Sisters of the Poor, and then the next day you find yourself orating on the need to protect the little guy. A judge's job is not to protect the little guy or the big guy. A judge's job, and a judge swears an oath to uphold the Constitution and to follow the law fairly, impartially, and equally for every litigant, little or big. In the past weeks as well, some of my Democratic colleagues have questioned Judge Gorsuch's independence and suggested that he needs to answer questions about the actions and statements and even the tweets of the president who appointed him. I would ask, was Justice Ginsburg or Justice Breyer asked about the sexual harassment suit that had been filed against President Clinton by Paula Jones? No, neither was asked about that suit. Was Justice Kagan asked about President Obama's incendiary comments at the State of the Union attacking the Supreme Court for a decision he disagreed with? No, of course not. Those questions were not asked because they were inappropriate political questions that have nothing to do with the record of the nominee before this committee. Justice Ginsburg, Justice Breyer, Justice Kagan were not asked those questions, and Judge Gorsuch should not be either. Instead, we should evaluate this nomination on the record, on the merits, and on that ground, I have every confidence that Judge Gorsuch will be confirmed as the next Associate Justice of the Supreme Court.
Senator Cruz, now Senator Franken.
Thank you, Mr. Chairman. Judge Gorsuch, congratulations on your nomination. You're a man of considerable qualifications and experience, and having reviewed your decisions, I can say that you're a man of strong opinions. But the task before this committee is not to determine whether you are a man of conviction. Rather, it is incumbent upon us to determine whether the views that you espouse and whether your interpretation of the Constitution take proper measure of the challenges the American people face every day. We must determine whether your understanding of our founding document is one that make real its promise of justice and equality to all Americans, black and white, immigrant, Native American, gay, straight, and transgender. We must determine whether your interpretation of our laws and the Constitution will unfairly favor corporate interests over working families or limit the ability of Minnesotans to get their day in court. The justices who sit on the Supreme Court wield enormous power over our daily lives, and so before this committee decides whether to advance your nomination, we have an obligation to fully examine your views on these important issues and to make sure that those views are known to the public. That's really the whole purpose of these hearings, to allow the people of Minnesota, the American people, to meet you, to decide for themselves whether you are qualified to serve. But Judge Gorsuch, having reviewed your decisions and your writings, I have concerns. In the days ahead, I will use this hearing as an opportunity to better understand your views and perhaps to alleviate those concerns. But in order for the hearing to serve its purpose, in order for the public to determine whether you should be confirmed. You must answer the questions this committee poses fully, candidly, and without equivocation. So I hope that's how you will approach our exchanges. Now, with that in mind, I think it's important to acknowledge just exactly how it is that you came before us today, and we've talked about this, namely the committee's failure to fulfill one of its core functions immediately following the death of Justice Scalia and before President Obama even named a nominee. My Republican colleagues announced that they would not move forward with filling the vacancy until after the presidential election. The majority leader said, and I quote, "The American people should have a voice in the selection of their next Supreme Court." The only problem with the majority leader's reasoning is that the American people did have a voice in this decision twice. Nonetheless, when President Obama nominated Chief Judge Merrick Garland, the Republican members of the committee responded by refusing to hold a hearing, a truly historic dereliction of duty of this body and a tactic as cynical as it was irresponsible. As a result of my Republican colleagues' unprecedented obstructionism, Justice Scalia's seat on the court remained vacant until my Republican colleagues' unprecedented obstructionism. Justice Scalia's seat on the court candidate Trump made no secret about what kind of nominee he would select. In fact, he openly discussed his litmus test. He said that he would, quote, appoint judges very much in the mold of Justice Scalia. During the final presidential debate, then candidate Trump said, quote, the justices I'm going to appoint will be pro-life. They will have a conservative bent. Now, Justice Scalia was a man of great conviction and, it should be said, a man of great humor. But Justice Scalia embraced a rigid view of our Constitution, a view blind to the equal dignity of LGBT people and hostile to women's reproductive rights, and a view that often refused to acknowledge the lingering animus in laws and policies that perpetuate the racial divide. Judge Gorsuch, while no one can dispute that the late Judge Scalia's love of the Constitution, the document he revered looks very different from the one that I have sworn to support and defend. So it troubles me that at this critical juncture in our nation's history, at this moment when our country is so fixated on things that divide us from one another, that President Trump would pledge to appoint jurists whose views of our founding document seek to reinforce those divisions rather than bridge them. This is an important moment in our history. The public's trust in our government and in the integrity of our institutions is at an all-time low. But that erosion of trust didn't take place overnight, and it didn't happen on institutions is at an all-time low. But that erosion of trust didn't take place overnight, and it didn't happen on its own. The American people's loss of confidence in our public institutions is more likely to side with business interests than any Supreme Court since World War II. Time and time again, the Roberts Court issued decisions that limit our constituents' ability to participate freely and fairly in our democracy. Decisions like Shelby County, where the court gutted one of our landmark civil rights laws and removed a crucial check on race discrimination at the ballot box. Or like Concepcion, a 5-4 decision that allows corporations to place obstacles between consumers and the courthouse door. Perhaps most egregious of all was Citizens United, which paved the way for individuals and outside groups to spend unlimited sums of money in our elections. It's no surprise that during the 2016 elections, voters from across the ideological spectrum, Democrats and Republicans alike, described our system as rigged. That's because it is. And the Roberts Court bears a great deal of responsibility for that. Now, in each one of the court bears a great deal of responsibility for that. Now, ask of evaluating his potential successor, I want to better understand the extent to which you share Justice Scalia's judicial philosophy, and I will be paying close attention to the ways in which your views set you apart. One of the ways in which your views are distinct from Justice Scalia's is in the area of administrative law. Just this past August, you wrote an opinion in which you suggested that it may be time to reevaluate what's known as the Chevron doctrine. Now, in broad strokes, the Chevron doctrine provides that courts should be reluctant to overrule agency experts when they are carrying out their missions, like when the FDA sets safety standards for prescription drugs. This principle, outlined by the Supreme Court, recognized that our agencies employ individuals with great expertise in the laws that they are charged with enforcing, like biologists at the FDA, and that where those experts have issued rules in highly technical areas, judges should defer to their expertise. Now, administrative law can be an obscure and sometimes complicated area of the law, but for anyone who cares about clean air or clean water or about the safety of our food and of our medicines, it's incredibly important. And Chevron simply ensures that judges don't discard an agency's expertise without good reason. Justice Scalia recognized this to be true. But to those who subscribe to President Trump's extreme view, Chevron is the only thing standing between them and what the President's chief strategist, Steve Bannon, called the quote-unquote deconstruction of the administrative state, which is shorthand for gutting any environmental or consumer protection measure that gets in the way of corporate profit margins. Speaking before a gathering of conservative activists last month, Mr. Bannon explained that the President's appointees were selected to bring about that deconstruction, and I suspect that your nomination, given your views on Chevron, is a key part of that strategy. So this hearing is important. Over the next few days, you'll have an opportunity to explain your judicial philosophy, and I look forward to learning more about how you would approach the great challenges facing our country. But if past is truly prologue, then I fear that confirming you would guarantee more of the same from the Roberts Court. Decisions that continue to favor powerful corporate interests over the rights of average Americans. During your time on the 10th Circuit, you have sided with corporations over workers, corporations over consumers, and corporations over women's health. What this moment in our history and our nation's history calls for is a nominee whose experience demonstrates an ability to set aside rigid views in favor of identifying common ground and crafting strong consensus opinions, someone like Merrick Garland. But your record suggests that if confirmed, you will espouse an ideology that I believe has already infected the bench, an ideology that backs big business over individual Americans and refuses to see our country as the dynamic and diverse nation that my constituents wake up in every morning. As I said before, I see this hearing as an opportunity to learn more about your views and perhaps to alleviate some of my concerns. So I hope that we are able to have a productive conversation. Thank you, Mr. Chairman.
Before the senator from Nebraska goes, I haven't talked to the person sitting there and can't get up and go, but I think when you're done, we'll take 5 minutes and you can do whatever you want to do. Go ahead, Senator from Nebraska.
Thank you, Mr. Chairman. Judge, this is a special moment in the life of our republic. We have an opportunity to stand back from more than 200 years of our history, to evaluate our civic health, and to recommit ourselves to a government that is intentionally limited, to powers that are intentionally distinguished and divided. That's what these next few weeks are actually about. Arguably, the most important thing the U.S. Senate will do this year is confirm the next Supreme Court justice. I want to focus my opening remarks around the simple image of a judge's black robe. It's a strange thing that judges wear robes. You people are odd. But it isn't something that we should just look past as an odd convention. It's something that we should look right at. It's not some relic from history that people wore long ago in an era of formality, like a powdered wig. So why do the robes exist, unfashionable and unattractive as they often are? The reasons are better summed up by a current sitting judge than I might be able to put them. And so I quote, "Donning a robe doesn't make me any smarter, but the robe does mean something. It's not just that I can hide the coffee stains on my shirt, It serves as a reminder of what's expected of us, what Burke has called the cold neutrality of an impartial judge. It serves, too, as a reminder of the relatively modest station we're meant to occupy in a democratic society. In other countries, judges might wear scarlet. Here, we're told to buy our own plain black robes, and I can attest to the standard choir outfit of the local uniform supply store as a good deal. Ours is the judiciary of an honest black polyester, close quote. The author of these insightful words sits before us, Judge Neil Gorsuch. And that statement is an excellent lens through which to view the work of the committee this week, and indeed the work of the court over the next century and beyond. I want to make three simple overlapping points about that judge's black robe. One, it changes the way that our eyes see the court. Two, it reiterates the calling of a judge to the judge. And three, it gives us a special opportunity to teach our kids something about their Constitution, the enduring paper that defines what our government can and cannot do. First then, how does it change the way we see the court? When you look at the 9 justices sitting together in their robes, they blend in with one another. It's hard to tell them apart if you squint, and thus it calls attention to the office rather than to the person. That's because when the judge puts on his or her robe, it forces their personalities into the background so that we can focus on the important but the modest job that they have to do, which is to drill down on facts and law. Facts are objective. They don't change based on your personality. They're evaluated against written objective laws, not against what the judge wishes the law said. Someone famously said that, quote, empathy, close quote, is an essential ingredient in arriving at a just decision. This belief is well meant, but it's very foolish. For standing before a court, your gender, your skin, your bank account cannot decide your fate. In the same way, a judge's race, class, and gender should not decide your fate. Empathy is actually not the role of a Supreme Court justice. It is, in a sense, our role, for we are men and women who've been hired and can be fired by the American people to empathize. We're to identify with the hopes and the struggles of 320 million Americans. But the judge, instead, has a different job, to faithfully and dispassionately apply the law to the facts of the particular case. The judge's robe is there to remind the judge and us of that if the facts are on your side, it shouldn't matter which judge you sit before. Our ideal is one where you can trade out one judge for another judge, and you should get the same outcome. This is the heart of what we mean when we say that we believe in the rule of law, not of men, or of women, or of black or white, or rich or poor. We are not to be ruled by a judge's passions, or by a judge's empathy, or by a judge's policy preferences. Here's the second thing that the black robe is supposed to do. It's supposed to reiterate the calling of the judge back to the judge. By way of loose analogy, many people across our country sat in church pews yesterday morning and listened to someone preach from behind a big wooden pulpit wearing a robe. Why the pulpit? Why the robe? Because these things make it harder to see the preacher. They help us all understand that yesterday morning, for those of us in that tradition, knew that it was not about the messenger, but about the message that was being passed on from above. It was also to remind the minister of the same cloaking. Likewise, a good judge on the bench knows that. It's not about you, so don't make it about you. I said that it's only a loose analogy because, of course, the job of a Supreme Court justice is absolutely not to deliver some eternal word from God. It's rather to interpret a man-made written constitution as objectively and faithfully as they can, inserting their opinions as little as possible. When you put on your robe, you're cloaking your personal preferences. You're cloaking your partisan views. There's not a red robe for Republicans. There's not a blue robe for Democrats. We issue here only black robes. This brings us to the third and final point, which is that the judge's robe is also to teach our kids how they should understand their Constitution. As all of us learned in Schoolhouse Rock, the judiciary is not only a separate branch of government from the president and the Congress, but it's also a co-equal one. We have different functions, but we have the same responsibility to be upholding and to teach the Constitution. As a co-equal, the court can examine whether the actions of the other two branches are in fact unconstitutional. Time and again, at important moments in our nation's history, the court has struck down laws passed by the Congress or put a stop to a president's executive actions. Here's what that means. The primary job of the Supreme Court is not to uphold the will of the majority of the moment. The primary job of a Supreme Court justice is not to reflect the popular opinions of the day. That might sound surprising. Don't we live in a democracy where the majority is supposed to rule? The answer to that question is only a very qualified yes, for there are critical limits to that statement. The Constitution is a decidedly and intentionally anti-majoritarian document. The Constitution exists to protect our rights and our liberties, even when we might hold unpopular views. And the role of the Supreme Court in protecting those rights and liberties is sometimes precisely to frustrate the will of the majority. Think about how the Constitution deals with religion and public opinion. The First Amendment prohibits the government from establishing any state religion, and it guarantees that every citizen can worship or not worship however their conscience dictates. If, however, at some moment polling showed a 51% popular desire in this country to pass a law making church attendance mandatory or to subsidize a particular religious denomination, the Supreme Court would rightly strike down such flawed laws. This is because in the Constitution, we decided that we would limit our own power. We, the people, decided in the founding of this republic that we would restrain our own majoritarian impulses. By enacting the Constitution, we intentionally decided to tie our own hands so that there are certain things that a majority can never do, like intentionally decided to tie our own hands so that there are certain things that a majority can never do. To cross that line, the Supreme Court will rightfully shout no. When Congress passes an unconstitutional law, it is in fact the Congress that is violating the long-term will of the people. For the judiciary is there to assert the will of the people as embodied in our shared Constitution over and against that unconstitutional but perhaps temporarily popular law. Each branch serves the people, but in unique ways. It is the job of the Congress and the president to act. It is the job of the court often to react. Each branch holds the others in check. Each branch faithfully seeks to uphold and teach the Constitution. Each branch serves the American people, but with distinct offices. When a Supreme Court justice puts on his or her robe, we don't want them confusing their job with those of other branches. We want them policing the structure of our government to make sure that each branch does its job, but only its job. Today, Judge Gorsuch sits in front of us wearing a suit and tie. Before he can put back on the black robe, he must answer this committee's questions. And I expect that Mr. Gorsuch, the citizen, has policy preferences. He probably has desired outcomes, but I don't know what they are, and that's a good thing. And I expect by the end of this week, it should be clear that Judge Gorsuch, the judge's judge, will faithfully embody the spirit of that black robe. For the American people deserve the comfort of a judiciary that is cold and impartial, not seeking to be super legislators. For if a judge seeks to be a super legislator, he or she should run for office so the American people can choose to hire them or fire them. But that is not the calling you have before us today. Thank you, and thank you to your family for being willing to endure this calling and this service and this hearing.
In 4 minutes and 59 seconds, I'll call on Senator Coons. Stand at ease.
Well, it looks like the chairman of the committee, Chuck Grassley of Iowa, will have a pretty tight timetable. He said just before the recess here that in 4 minutes and 59 seconds he was going to call on Senator Coons. He's next in line for the Democrats. Recess here that in 4 minutes and 59 seconds he was going to call on Senator Coons. He's next in line for the Democrats of Hawaii. And 4 Republicans still left to ask questions. Senators Flake, Mike Crapo of Idaho, Tom Tillis of North Carolina, and the newest member of the committee, John Kennedy of Louisiana. The hearing got underway at 11 o'clock this morning. This is day number 1 of 4 days of hearings for Judge Neil Gorsuch, nominated by President Donald Trump on January 31st to fill that 9th and final seat on the Supreme Court. Today, opening statements. You'll hear from the senator. You'll hear from Judge Gorsuch, who will be introduced by the 2 senators from Colorado. And tomorrow, the questioning begins tomorrow and Wednesday, expecting questions for Judge Gorsuch with witnesses both pro and con, for and against the nominee expected on Thursday. Just to let you know about our schedule, again, this is a short break. They'll gavel back in momentarily. We will re-air all of today's hearings beginning tonight at 8:30 Eastern here on C-SPAN 2. And our coverage tomorrow will be over on C-SPAN 3 beginning at 9:30 Eastern. As we said, tomorrow starts the beginning of questioning. So you can follow that on C-SPAN 3. We're streaming all of this online at cspan.org, and you can listen to it all live on the free C-SPAN radio app. The committee today, Chuck Grassley, the chairman, announcing that the committee will vote on the nominee on April the 3rd. The Examiner writes, Washington Examiner writing that plan for the vote on the Gorsuch nomination is 2 weeks after the start of his nomination hearings and several days before Congress adjourns for its Easter recess. One more quick note, too. Another major hearing happening on Capitol Hill today. It's been underway for a couple of hours, still going. This is the House Intelligence Committee hearing on Russian hacking in the 2016 elections, and you can follow that now. We're streaming that live on cspan.org. We're also covering it live now on C-SPAN 3 throughout the day, and it's also live now over on C-SPAN.
The judge isn't here yet, but if you take your seats, he will be momentarily, and then we'll start with Senator from Delaware.